The Parks, I serve on City Council, and I have done so since February 17, 2015.
Awesome. Wow. Greg Huber, Planning Commission, and I think we determined 3 years last time.
Kim Travis, Planning Commission, and about a year.
Kyle Simica, I'm on DLC and 3 months.
Lisa Beatty, City Council, I'm ending my 3rd year.
John Burns on the Planning Commission, a little over a year now.
Mark Gamba, City Council, coming up on 5 years.
Sherry Grobb, Planning Commission, just about a year.
Scott Jones, I'm the rookie on Planning Commissioner, about 6 months.
Mike Carente, DLC, about a year and a half.
Angel Falconer, elected to council last November.
Cynthia Schuster, DLC, about a year.
Mary Newstadter, DLC, I've been to 2 meetings.
Cool.
Peter. I'm Peter Watts. I'm an attorney at Jordan Ramus that you infrequently see because I'm only here a couple times a year. I am the city attorney for, let's see if I can remember them all, Dundee, Estacada, Gerhardt, King City, Scappoose, and St. Helens. So that keeps me somewhat busy. And is there a clicker so that I can advance?
Scott, no, about your place. There's the arrows.
Okay. All right, so we're here today to do some training about what can potentially go wrong, both before and during a hearing, and then how can you remediate it. And for almost anything that happens, you can remediate it unless there's a problem with notice. So if it's a Goal 1 notice problem or a Goal 2 participation problem, then you're going to have to set over the hearing and make sure that people get adequate notice. There's actually a recent LUBA case that says that if someone didn't get adequate notice but showed up anyway, that was okay. Though you could tell that the LUBA was really not happy that that was the decision they had to make, and it was pretty strong language, but ultimately they said the question is whether someone did have notice. So as you're looking at these things, as you're looking at these hearings, the first question is it legislative in nature or is it quasi-judicial? And that really determines how you need to proceed from there. Because if it's legislative, then it means that you don't have to worry about things like ex parte contact. You don't have to worry about if you've made statements in the newspaper that you really like a project or you really don't like a project, or those sort of things. You're acting as a member of the legislation, and your job is to implement the visions and values of the city of Milwaukee. When you're in a quasi-judicial mode, though, you're acting as a judge. And so when you're acting as a judge, the standards are impartiality and that you're not biased. So if you have an issue, if you aren't impartial or you are biased, and there's a pretty high bar for both, but we'll need to take steps in order to remediate that. Because again, these are things you can cure, but what we wouldn't want is for a challenge to be made and then not cure it, and then there to be a LUBA appeal based on that. So the determination is made by case law and also by your code. It's interesting because a lot of cities don't have a code section that says that this sort of thing is quasi-judicial or this sort of thing is legislative, but you do. So we look to both. And here's the legal test, and the case is Strawberry Hill Four-Wheelers v. Benton County. What's interesting is this was a group, a 501c3 made up of four-wheeler aficionados, both a state association and local, and Benton County was vacating a road. And it was a road that the four-wheelers liked to ride on. And when a city or a county vacates a road, what that means is to the center line goes to the property owner on each side. And so what that meant then is it becomes part of people's yards and not no longer a road that four-wheelers can ride on. And they were pretty upset about this. And the way that the county commission in Benton County did that, and you can see the date, 1979, is they did it via a writ. And why that is interesting is that you can't appeal a writ. So what they said is, this is county business, and we can do this via a writ, and sorry, four-wheeler fans, there's nothing you can do about it. And then they didn't make very good findings at all. And so what it came down to, there are a couple of things, is when can you utilize tools, and then what do you need to determine whether something is legislative or quasi-judicial. And so the first factor, and the courts have said at different times that one factor is more important than others. So in the beginning it said all three factors are to be determined equally. It's turned out over time that's not the case. The factor one is the most important one. So is the process bound to result in a decision? So if you have a land use application in front of you for a zone change, whether it's for a single property, for a larger property, and someone has filed that application, and you know you have 120 days in order to make a decision, whether it's rejecting it or approving it or asking them to toll that timeline so you can have another hearing, you're going to, at the end of that process, you can't just walk away. So you can't say, I don't think we want to decide that, so we're going to table it and move on. Within that time period, you're going to have to make a decision. Versus if you're doing something like a downtown master plan, unless it's required by state law, you don't have to make a decision. You could hire consultants and you could go through it and you could say, we just don't have anything we really want to adopt. We're not ready to make a decision at this time. We need more stakeholder support. And there are no timelines there. In this case, in that instance, you're not bound to make a decision. So that would tend to go towards something that's legislative. So is the decision bound to apply pre-existing criteria to concrete facts? What courts have said recently about factor number 2 is that every decision is bound to apply pre-existing criteria to concrete facts, whether it's legislative or quasi-judicial. And so they just now assume that you've met that second factor. And then the third is probably not as important as the first, but courts have said also quite important. So is the action directed at a closely circumscribed factual situation or a relatively small number of persons? And as we look at that factor, the problem is there's no bright line rule. So there are instances where a larger number of properties were annexed or were zoned differently, and courts have said in some instances that's okay, that's not. So there's no bright line rule of how much will tip it into one or the other, though your code certainly attempts to do that. So there, I obviously have read my slides too many times. There is no bright line rule. The answer to each question must be weighed, and no single answer is determinative. The more definitively questions are answered in the negative, the more likely it is that the consideration is legislative in nature. So something like a downtown master plan, unless it's part of a comp plan, like a transportation system plan that's required by state law, if you're revising something in your downtown or doing new criteria that you're not bound to follow through on, then it's probably going to be legislative. So here's factor 1. If a city can terminate the process of consideration at any time, then the process is not bound to result in a decision, and the first factor is not met. And there are a number of instances where people have said, no, you have to make a decision, you have to carry this further, and the courts have said, no, you don't. I mean, it's purely up to you to decide whether to move forward or not. And I think we can all think of instances where you've adopted things that aren't required under your code or by state law. It's just whether it's something related to pesticides or bees or something of that nature. At any time during that process, you can abandon that process and bring it up later. It's not like someone who wants to put an addition onto their home. Second factor is present in most land use decisions, and so it's less than the other two. And again, most LUA decisions just summarily assume that the factor factors met and skip the analysis altogether. And that's what we've seen recently. Then this factor 3 is where there's probably the most play, because it's generally apparent whether or not something needs to result in a decision, and the second factors are probably going to have been met. But this is where things can get a little dicey, and the reason is because the LUBA opinions on this have been all over the map. So where a 2,400 foot section of a minor arterial would affect more than 40 properties, then it's probably not going to be a quasi. So here's your code, though, and it is a unique and interesting code. And so what it says is that, at least in the context of plan map amendments, that the city attorney reviews the process, the city attorney makes a determination, and that is not a land use decision per ORS 197.015. And then it does give the city attorney a little bit of guidance. Generally, comprehensive plan map amendments that involve 5 or more properties or encompass more than 2 acres are legislative in nature, subject to Type 5 review. Comprehensive plan map amendments that involve fewer properties encompass a smaller area of land are quasi-judicial in nature and subject to Type 4. Whether or not, if that was ever challenged, that the city attorney has carte blanche to make the determination, it's not a land use determination that you could later challenge. I do not know what your odds of success would be in that instance. I will say, though, that 5 or more properties, more than 2 acres, versus the other, at least there's kind of a standard in there that establishes a level of reasonableness. Though I can easily see how more than 2 acres could be, whether it's a single property owner or just closely circumscribed facts, how I would think that was probably more of a quasi-judicial, or whether you could have more owners, particularly like in a condominium. And it really wouldn't be, it would not be a legislative. So the same is true of the plan map amendments. Again, it gives your city attorney a lot of power to make the determination. It purports to say that it's not a land use decision that's appealable, and then it provides that criteria: 5 or more properties or encompass more than 2 acres of land or legislative in nature, and smaller than that, they're not.
So, Peter, I guess inherent in all of that, and what you're implying is that applicants want it to be quasi-judicial generally. I mean, that's who's going to challenge this, is somebody who wants it to be quasi-judicial because we have more constraints as decision makers than if it's legislative.
Well, they might or they might not. What it impacts is it impacts notice. So if it can impact notice, and it also can impact your role is, I'll call it, an investigator. And so that's where this really comes into play. And so if it's something legislative in character, if it's a large number of acreage that you're going to change its designation from a R1 to an R5 or whatever you're doing with it, then it's important to understand what it is, because if it's legislative in nature, you don't have to keep track of all of your ex parte contacts. You don't have to wonder about what have you said to someone. You don't have to be concerned that, did you do a site visit? Who did you talk to at the site visit? Who have you talked to about the site? Have you reached out to experts? Those sort of things are not going to come into play in a legislative hearing. They are all going to come into play in a quasi-judicial hearing, and a property owner is going to have the opportunity to bring those up and say, lack of due process, the city hasn't complied with goal 1, the city hasn't complied with goal 2, whatever it is, whatever argument arguments they're making.
But if there's a clock on it, if there's a 90-day clock, that by itself makes it.
Not necessarily. I mean, if it's that's just one of the three factors. So if a decision has to be made, and so if someone wants a zone change, let's say they want to go from R1 to an R7, and they come to the city council and say, you need to do this. There may or may not be a clock on that, but I don't know that that's necessarily going to end up being a quasi-judicial matter. And this is why we work with your planning staff, because a lot of times they have a far better understanding of what the project is and what the people are seeking to do than the attorneys. And so certainly in the past, when I staffed your planning commission, I would work with Denny and Denny's predecessor, because we had situations that may have been more than 2 acres or more than 5 owners, and there is some discretion there. And one of the reasons is because if the amount of notice shifts, which it does, and your staff has already noticed something as a quasi-judicial, if then the city attorney comes in and says this is legislative, then they might have to renotice, and then we have to worry about compliance with Goal 1.
If I could just try to clarify for both the planning commission and DLC for a moment.
Do you have the wireless mic? In almost all the cases that have come before you guys, there's an applicant for the quasi-judicial applications. That doesn't mean an applicant that's not the city. And in most of the instances that have come before you, if the city is the applicant, it's sometimes legislative and sometimes quasi-judicial. And it depends. And that's when you would apply those tests that Peter was talking about. But the key thing there is, like all the text amendments that we do, those are almost always going to be legislative in nature. And if it's a text amendment with a map element to it, it's almost always going to be legislative. For the DLC, you see a couple different types of things that come before you, and your role is a little bit different in that it's purely advisory. But we try to be pretty careful when you are doing reviews of applications by an individual to try to at least treat it in a quasi-judicial manner. The work you've been doing on the guidelines is all legislative. So I just wanted to make sure that you were putting those things in the right categories there that Peter was talking about.
Thank you, Denny. So the first question is a bias determination, and this isn't a charge that we see a lot. What's interesting, though, is that if it starts getting made, then it can get, once you kind of open it and people are making claims of bias, and it's rare that the people that are making the claims of bias actually understand the test for bias, but that doesn't keep them from arguing that you're biased. But once that opens, it's kind of like when city councils talk about censuring each other, which again is something that under Oregon law, not even clear whether it's legal. But once the conversations start happening, they seem to happen a lot. So it's kind of, the bias is kind of Pandora's box. Once it gets opened, and people hear that word bias, then they will potentially make the charge and say you're biased. You already know how you're going to vote on this. So if an elected official is accused of bias, the decision must be made whether the elected official should participate in the quasi-judicial decision. And that is, the scope of the determination is narrowly limited to the specific decisions before the council. And the council must find that the bias is actual, not merely apparent, and that the elected official is so prejudged that matter as to be incapable of determining its merits on the basis of evidence and arguments presented. And this creates just an incredibly high bar to proving bias.
So the council itself rules on a counselor?
The counselor themselves can choose to recuse themselves from the matter after the charge is made. If they decline to do so, then it would be recommended that the council take it up and have a discussion and the person be able to explain why they have not prejudged the matter. So the other requirement is impartiality, and the case is Fasano v. Washington County Commissioners. And the way that impartiality oftentimes is established is if someone has ex parte contacts. And so that's why at the beginning of your hearings, there's always a question of, has anyone had ex parte contacts? Because the three factors that the Oregon Supreme Court looked at in this case were the contacts with disinterested persons, did it amount to an investigation of the merits of proposed change, and most importantly, were made a matter of record so that the applicants had an opportunity to respond. And so in instances where we see either members of a planning commission or as the city council acting as investigators, and this can occur and does occur, sometimes that investigation might be as small as a site visit, which is why that question is asked, have you been to the site? Sometimes it can involve that person gathering evidence, consulting with experts, doing all of those things. That is not per se going to create a problem, but the key to that is getting that, whatever you've learned, into the record as soon as possible in the process. So if you go out to the property and you look at it and, something's clearly amiss or there's something that you see that you want to make sure everyone sees, and so you pull out your phone and you take a picture, the key is to get that in the record like the next business day and say, hey, I was at the site and I have some concerns. Here's a photo that I took. I have some concerns. And the reason is because the key is that the applicant have sufficient time to refute it. So if you've got it in like a month before the hearing, they have notice of it, they've got the picture, and they can say, that's not what's actually on the ground, or what you saw is this and not that, and they have an opportunity to deal with it, then you're probably going to be okay in your investigation. If they don't have sufficient time to say why, to basically deal with those facts, then that's going to create a problem, and it might be worth kicking it out 2 weeks. It just depends. And so, to the extent that you're going to do investigations, and I know that some of you are, document what you've done, document who you've talked to, and get it to your staff so they can get it into the record. So what constitutes impartiality and bias? There's no definitive case, but this case, the Columbia Riverkeeper v. Clatsop County, I think illustrates how high the bar is for bias. So the factors that emerge is the scope of the matter, question issues narrowly limited to specific decisions, and because the nature of elected officials making decisions in quasi-judicial proceedings, the bias must be actual. And then third, the substantive standard for actual bias is that the decision maker is so prejudged particular matters to be incapable of determining. And so some of you might remember the LNG project from Clatsop County. It was in the Astoria area, and it was extremely controversial. And riverkeepers and many other environmental organizations organizations were very concerned about this. They had a split county council split county commission. It was unclear how that group was going to rule on this. It was quite possible that the LNG facility was going to go through. And so we're starting to get into the factors that ultimately were not biased. So Commissioner Huddala had run for office on a platform opposing liquefied natural gas. Prior to taking office, after he had been elected, he said, we're getting closer to the point where these LNG projects will be shut down. Then we can fully celebrate. In the meantime, let's take every opportunity to vote for leaders that will properly represent us. Let's give credit to agencies that do the right thing. He had been involved in litigation as a plaintiff, trying to shut down a different LNG site, not the one in that county, but in another county. And as a result, after he got elected and within months of his election, they were there. And there's the application for the project. And the question of bias was raised. And they're like, you're biased. Look at this. You've been a plaintiff in a lawsuit. You have been, you wrote this op-ed and you campaigned on a single issue, which is like, we need to shut down this LNG plant, which seemed like pretty clear evidence that, someone could make. And so what he did very wisely is he repaired that bias. And it was a very carefully crafted statement that took into account the case law in Oregon on bias. And he made this statement that he had clearly expressed concerns about these projects in the past. And he mentioned why some of the factors that made him do that. And that some of the issues have been raised in the Bradwood situation. That's the one they were looking at. He said, my reasonable concerns don't cause me to prejudge the situation. That was critically important for him to say. He said, this is a complex application. There is nothing that prevents me from assessing the facts under review. I have the ability to set aside any personal views and evaluate, discuss, and vote on matters of fact. Of course, I express personal opinions while campaigning. Citizens often expect politicians to have opinions, but past association or articulation does not predict future decisions that will be based on the record of facts. I enter this hearing without preconception. I understand my responsibility in a quasi-judicial setting. I take it seriously that I need to remain unbiased during this process, set aside personal views. We all have personal views. One thing that I've been elected to do is sit impartially in a quasi-judicial setting and make decisions based on the facts. And he read that statement, and then he listened to all the evidence, and then, unsurprisingly, he voted against the LNG facility, at which point it was challenged, and it went all the way up, and what the court said is, like, he checked all the boxes. He explained that, yeah, he had personal feelings, anyone would, that he understood what his role was. It was to be clear and objective, that he could apply facts and criteria to the decision-making, that he hadn't prejudged it. And that's really what he needed to establish. And even though the record was a big record, they said they didn't find bias. Here's where they have found bias. This was at the hearing, and this guy said he believed he was elected on a mandate to support the proposed siting of the church. So, like, out of the gates, he's like, I was elected on a mandate to support the siting of this church. And they're like, bias. And, that was determined to be bias. So, obviously, he did not get to his lawyer prior to that hearing. So, moving on to conflicts of interest, because this is another thing that all of you get to deal with and is in the front portion of your hearing. There are two types of conflicts of interest: the could or would. And in an elected official or commission member has an actual conflict of interest if his or her action, decision, or recommendation will be to the private pecuniary benefit or detriment of the elected official, or the elected official's relative, or any business with which the elected official or his relative is associated. So if you think, before I go through and provide some more information on conflicts of interest, if you think you might have a conflict of interest, or if you have a conflict of interest, what you need to do is call the Oregon Government Ethics Commission. And they will make that determination for you. And they will usually get back to you within 24 hours. They can usually give you an answer on the phone that day if you need something in writing. It's usually within a day. That's what they do. Our liability insurance doesn't cover us making determinations on conflicts of interest because they so didn't want city attorneys and county council to make those determinations that they said, we won't cover you if you make a mistake, so that should incentivize you to have people called OGC. And for me, at least, that incentivizes me. So the two types of conflict of interest could or would. So if it's like you're, if you're the only company that imports a certain type of limestone and you decide to spec limestone in the building, that's going to be to your interest because you're the only one that does it. If it might, like if you're in the lumber industry and you decide to add wood as a construction material that can be used in construction, and there are like 8 other lumber yards, you're not going to have a direct conflict of interest. You're going to have a theoretical one. So the class exception, so if the conflict's because of any interest or membership in a particular business, industry, occupation, or other class required by law as a prerequisite to the holding by the person of the office or position, that's not going to be a conflict. So if you're on LUBO, which would require you to be a lawyer, that and something came up because you were a lawyer, that wouldn't be a problem because that would be a requirement of the duty. So this is the second one, which would affect to the same degree a class consisting of all inhabitants of the state or a smaller group consisting of an industry, occupation, or other group. So if this is going to impact everyone equally, so if let's say you were in the cannabis industry, but you decided, and there were a lot of other people in the cannabis industry, and you decided to make cannabis illegal in the city of Milwaukee, that would impact everyone in Milwaukee that was in that industry to the same extent as it impacted you. And so you could get around that. Though again, you need to call the OGC, you need to explain the facts to them, and you need to get a letter, not just for your own protection, but for the general public, so that you can say, like Greg can say, I work at a place that sells lumber, and we're allowing wood as a construction product, and I called the OGC, and I got a letter from them, and they said it was fine under this exception, so I don't have to worry about it. And he might know that, and you might know that, but members of the general public who've seen him, working there, might not know it. And so when he says, I got this from the OGC, they determined that I don't have a problem. It's not just for his benefit, it's for the general public, so that they believe that, the system isn't rigged and that he isn't doing anything wrong. And that can prevent a lot of issues right there. So finally, there's no potential conflict of interest for pecuniary benefit or detriment arising from a person's membership in or membership on the board of directors of a nonprofit corporation, a 501c. So whether it's a 501c6 like a Chamber of Commerce, or it's a 501c3 like a arts organization or something like that, your membership in that is going to be an exception. I still recommend going to the OGC because someone could be like, Will has been affiliated with the Chamber for so long, she shouldn't be voting on a grant to the Chamber, and she could say, well, I have this letter from the OGC that says that this is not a conflict of interest and that we're fine.
So Peter, quick. So we had Bob's Red Mill, who I sit on the Milwaukee Historical Society board, and they are a corporate member. And I did not call OGC, which I called them before. It's an interesting process, but I did claim a potential conflict of interest, I guess, that since I'm a board member and that they are a member, but I'm not a paid position on the board. Was my
Right. So, like the fact that you're on the Milwaukee Historical Society's board, because I'm assuming that that's a 501c3 organization, is not going to result in a conflict. But it's a good idea to call the OGC because members of the public aren't going to know that, and it's good for you to demonstrate that to them. That, some people might think I have a conflict. I don't, because the OGC says that I don't, and here's the exception. So there's the information right there, 503-378-5105. I have found them to be really quick to turn things around unless you have something just extremely unusual. And then it's maybe 48 hours at the most. To get a letter, it's usually less than 24. If you need a letter that day, they can probably get it to you as long as you're not calling them at like 4:50. I mean, they really work hard to try and get this turned around because they want you guys calling them. They don't want, because if you don't call them and then someone files a complaint, they're the ones that have to investigate it, and they're the ones that ultimately have to do all the work, and so they're all about preventing that from happening on the front end so that you don't have a problem, and neither do they.
Can you do that via email now?
Yeah, you can.
The OGEC is also the same entity that planning commissioners and councilors report their statement of economic interest to on an annual basis. The Andy are the same group.
Yeah. And they also are the ones that investigate violations of public meeting laws. So what they look at are conflicts, public meetings, executive sessions, of course, and then they are both the advisor and the investigator.
And so if you have an actual conflict of interest, you have to recuse yourself. If you have a potential conflict of interest,
You don't have to recuse yourself unless you want to, but you need to put it on the record, and you need to,
I mean, I would say in my, between 3 years city council and 9 years planning commission, I've never seen this be an issue. I mean, I think most of us err on the side of recusing ourselves if we're in any doubt, and I think that's a good rule of thumb. Personally.
Like Shane will say, I work at Metro, but I don't work in the, if we have, whether it's housing or something like that, I mean, that's a disclosure that he makes, and he doesn't have, I don't even think that's a potential conflict of interest, but I think it is good for, the audience, for the public, that they understand that, he's disclosing that, and it really saves him the trouble if someone later were to claim that he does have some conflict of interest, and it's the same thing if you're in an industry. I mean, there's that exception right there, but members of the public aren't going to know that, and so by going to the OGC and then by saying, I was worried about this myself, and so I approached them, and this is the written advice that they gave me, and they say that I can participate. What you're really doing is providing the general public with assurances that the process is fair and that you're impartial, and that's what we want, because we want them to understand that you guys aren't biased, and it's not self-dealing. You're just doing the work of the city. All right, so this is something that is to be avoided, which is faulty notice, and this can happen quite a bit, particularly if notice is being given. Oftentimes, like Multnomah County will send a postcard that says that something's going to go up for people to check, and then it'll be on their website, and there'll be a link, and like the link will be broken, and so that is is a error that I will be arguing to LCDC this Friday, that Multnomah County did not adequately provide notice because the link less than 2 days before the hearing that would give you their ordinance was broken. People were emailing them, including people that were required under Goal 2 to participate in the process, that were like, I don't know what you're voting on because we can't get the ordinance, and they decided to move forward. And whether that'll be a problem or not, we'll find out.
Is that a common issue?
Yeah, I think with the technology it is, because you hope that, and hopefully it isn't in Milwaukee, but you hope that people can access the documents, and sometimes they can't. And this was kind of I don't know, everything just happened at the last minute. They sent email notice at like 10 o'clock at night on a Friday, and then on Tuesday their link was still broken, and I don't know why that happened, but it did. And the record, what was interesting to me as I was going through the record, is it was replete with people that are like, what are you voting on? I don't know whether I need to be there or not. And so that's not what we want, particularly if something's going to be controversial. We want people to get the information as soon as they possibly can so that they can make plans to attend the hearing. I mean, whether they need to get a babysitter or whether they need to, take time off for work or whatever they need to do, that they have time in order to do that. If they can't be there in person, that they have time to submit written testimony so that they can participate in the process and know that their voice is being heard. So I just, with the technology is a blessing and a curse. I mean, it certainly allows, like I was like, what time do I need to be there tonight? So I checked your website. There it was, 6:15. But on the other hand, if the technology doesn't work, then in the notice is just a postcard saying check our website, then that can create problems. And the problem with a Goal 1 is probably the most important land use goal, of course, has said that, which is public participation. In Goal 2, it's coordination, which is why as you're going through an application, CCFD1 gives comments on it, and they might ask for a condition, or they might say, I have no problem. That's Goal 2 coordination that's happening. And if those things don't happen the way they should, months and months can go by, and suddenly you're at LUBA or LCDC, and the whole thing can get kicked back. And then you're starting over again. And it's pretty damning that, if the people have said you haven't provided the public notice adequately, or it's so time consuming that it's to be avoided at all costs. So the question is a party prejudiced? And that's why I mentioned the LUBA case earlier. In that case, the person had submitted written testimony and also shown up. There wasn't any question about whether the city had not complied with the public notice. They hadn't. But LUBA looked at it and they said that the party wasn't prejudiced. Where it could be a problem is if someone had participated previously, the notice wasn't adequate, and then they said to LUBA, I had all this stuff I wanted to give to the city council. I wasn't aware that this was happening. I wasn't able to participate. And so I've been prejudiced as a result of that. And if that's the case, then it could be kicked back. The remedy, you can have the hearing, you can continue the hearing until a date certain. Oral notice, if it's going to be continued at a date certain, is sufficient. Oftentimes, if someone brings that up, if they're there in person, but they say, like, my neighbors didn't know they needed to be here tonight, it's probably a good idea to go through the hearing and then let everyone testify and get their stuff in, and then continue it. If you think you might actually have a Goal 1 issue, then have it go all the way up and then come all the way back down.
So when you've got a clock that you're on, and you're in a situation where you're at the end of the clock, doesn't want to extend, and you have a faulty notice about that.
Well, then you would have to either hold an emergency meeting like the next day, or you would have to make the decision understanding that you're going to be defending the notice and hoping that nobody shows up that says, I wanted to participate and I didn't. Because that's what if someone's there raising hell at the hearing, I haven't had, adequate notice. There are things that have given me pause, like I would have gone to this expert and gotten this report if I had adequate notice, but now I didn't have time because I only found out about it this afternoon. I mean, that would give me more pause, but if they're there in person, it's going to be, under the case law that we have now, it's going to be tough. If they're not there in person, so if they participate in front of the Planning Commission or they sent in testimony previously, they didn't know about the hearing, and they're able to say, I had no idea about it. I was sitting at home, I would have been there, I had all this data that I wanted to put in the record, here it is, and that data could have changed their minds. Then suddenly, we might have an issue. But keep in mind that you can have a special meeting, you can have an emergency meeting. I mean, there are ways to cure this, unless the deadline is literally the next day. But I think your staff's really careful about notice. I think this is less of an issue in Milwaukee. And all of the stuff that I've ever seen is coordinated with all of the Goal 2 parties, so CCFD1, Parks, if that's applicable, whoever is applicable. There's coordination, and they either put something in the record or don't, and staff says, we got these comments, or they told us they didn't have a problem, whatever it is all in the record. And unfortunately, other jurisdictions don't do that. Like Multnomah County, we had the fire chief, the fire marshal saying, what are you voting on? And your link's broken, and how is this an appropriate public process? So he actually raised the fire marshal, the Goal 2 coordinating party, raised the Goal 1 issue in the record, which is not, if you're representing Multnomah County, that's not what you want in the record. I mean, those aren't facts. Whether anything happens as a result of that, I don't know. But those aren't the sort of facts that you want in the record, because what you want to be able to demonstrate, whether it's LUBA or LCDC or if it goes up to the Court of Appeals, is that you did everything you could to ensure that people were able to meaningfully participate in this process, because that's kind of the Oregon way, is meaningful participation, which is why people complain so much about the process.
Peter, so if, in this case, we could have somebody that goes to DLC, then it comes up to the Planning Commission, then it could get appealed to the council. So does somebody have standing if they spoke at the DLC and they didn't get notice to speak at the planning or at the amendment of the city council?
If they spoke and then didn't get notice of the next process, they could, they should get notice, so they can bring that up. If they show up and are like, well, I didn't get notice, then we go back to, is the party prejudiced? And if they're there and they've got all their data and they're like, I should have gotten an email, but I didn't, they're going to have trouble demonstrating that they were prejudiced because they're there in person.
So, related to that question, because the DLC is public recorded, we have meeting notes by them speaking at the DLC, and the fact that they're going to probably be in the meeting notes, does that constitute due notice by their part?
So the way that they're able to appeal a decision is if they participated either by giving testimony or participated in writing, arguing for or against the claim. So if you approve it and they said you shouldn't, then regardless of where you are in the standing. And does yours automatically go to the planning commission?
There are suggestions for.
Okay, so yours is going to go up regardless. If they show up at the planning commission and testify against it, and it gets approved, and goes, then they have the ability to appeal it to the city council.
We've only had a couple of these so far, we had a demolition and then review of the gardening project. We've got two that have happened where DLC discussed it, that their recommendation was then forwarded to the planning commission. And I don't know how we dealt with I'm assuming that the meeting notes weren't prepared and given to the planning commission. What I think we did was summarize this decision and provide that. And I don't know what we did with any testimony that was provided. But this gives us some guidance as to making sure that we document that testimony well as we move it up.
So, yeah,
Did you get public testimony before the DLC on those? You did, okay.
so that was actually a question I had. Is public testimony before the DLC
Part of the record.
Yeah.
I would say that it should be, because again, all these rules are designed to allow participation, and so plus if someone knows that what they wrote is going to be in the record, then maybe they're not going to show up to the planning commission and read their letter that they submitted to, or maybe they will. They usually will, but you can hope.
Goodness. Yeah, they will.
Like, you're reading what is in the record, and we all read it already. So, so here's another thing that comes up, and this is when you have unclear or ambiguous terms in the code. And is that interpretation entitled to deference? The city council is entitled to a large amount of deference in interpreting their code. The planning commission is not. So, sorry, planning commission. The good news, though, is that if someone's going for a variance or something like that, and you've got your criteria of is it outstanding architecture? You all, there's no bright line rule for outstanding architecture. You're all able to substitute your judgment in that. However, if then an issue becomes if someone's they misapplied what outstanding architecture means, your city council, fortunately, is able to say exactly what it means. And so there are cases where LUBA has said it's clear the standard is clearly wrong, which obviously is a pretty high bar as far as the amount of deference that the city council is entitled to in interpreting their code. So this is how to interpret. Advice from city staff: make the interpretation clear for the record so the council and parties understand the reasoning. And that's the most important thing. So if you're interpreting your code and you're saying, I'll use another example that I was involved in. The question was it residential character? And so it became important for them to define what residential character meant to them. And they were entitled to a huge amount of deference. But they needed to say, this is what residential character means to me. This is how I interpret residential character. And then the other counselors said yes. And if you don't do that, and a lot of the way that you learn these things is by making the mistake. I did not have a city council interpret what the word density meant, because I didn't think that we needed an interpretation on what the word density meant. I then had two lawyers arguing at LUBA that residential density meant the number of houses that were occupied as the primary domicile. So the primary residence, that that was how they interpreted density. So then I was at LUBA arguing, no, it's how many units per acre. And ultimately, LUBA agreed with me, and there were seven other arguments they had, but ultimately they agreed with me on them. But again, if there's, what I learned from that is, if there's any ambiguity, have the city council make the interpretation for you so it's clearly in the record. And unless you guys are clearly wrong, then it's probably not going to get kicked back, and hopefully your lawyer won't have to be a LUBA.
But here, we often have director's interpretations, right, of some of the
Well, that's one
terms.
process.
Yeah.
I mean, and we will, if we have a question about interpretation, we will usually list that out as one of the decisions that sort of needs to be made. Whether or not we would go to council first to ask that question, that would add a process, and would that actually end up?
No, Denny, I wouldn't recommend that you do that. What I would recommend is you give your staff interpretation, and at the meeting, the council say, we've heard our staff, I agree with their interpretation, or, I agree with staff's interpretation, I additionally, so you as a counselor, the most important thing to get in the record is that you agree with staff's interpretation, or to the extent that you interpret it a little bit differently, do you get that on the record, and then we have a majority of you that are on the same page doing the interpretation that will result in, the approval or denial. Because then once we have that, and it can be simple as like, Denny explained what the standard is, that's how I interpret it, and we're good.
What if more of the public or the other parties disagree with the staff's interpretation?
So then what you do at that point is say which one you agree with and say why you're agreeing with them. And this comes more into play with expert testimony. So sometimes like the city may hire housing expert to determine housing need for the city, and then an applicant might come in with their own expert, and so you have dueling experts. In that case, you'll want to say why you're giving more weight to one expert than the other expert.
So traffic studies is where we see that, I think.
Yeah, I mean, any of these studies that are open for interpretation, you can have dueling experts, or you can have an expert, and that your staff members are experts. But you can have, there are instances where someone gives lay testimony and city councils are like, I agree with that over the expert, and here's why. And what the cases have said in those instances, as long as they clearly articulate why they agree with the one viewpoint and why they're interpreting that way, then they're entitled to vast amounts of deference, and they reverse or remand only if the city improperly construed the applicable law. So.
One other thing I might note is the code allows for a formal director interpretation on things. So in some instances, especially type 1 decisions, things that are at the city staff level, I mean, I made an interpretation once about how we measure sign area. The applicant appealed that to the Planning Commission. The Planning Commission overturned the director decision. So we've been through that process once. And then we went back with a code amendment and aligned it more like the director decision at 1.0. But it was, there were reasons the commission did what it did. It was like because that similar interpretation had been made across the street. And I think the applicant was quite articulate in the way they described that. I just had argued that the previous decision across the street was wrong.
Which it was.
Which it was, yeah. But there is a process for for interpretations. And what I was trying to say earlier is if it's a type 3 decision that might be or even a
a type 3 decision that might be going to the Planning Commission, or a decision that might be going to DLC, where that recommendation or decision requires interpretation, we're just going to spell out that for you about what choices you might have before you make your decision. And I can't think of an example, but I know we've done that recently where we've had that, where you've needed to interpret something in a certain way, and we've described that in the staff report, and it's allowed us to get over that question. And then if somebody had a problem with it, they can appeal that part of the decision forward. So we're always trying to look out for those types of things so that we can provide an applicant an avenue to argue it if they need to.
And this, and then making sure that you make your decision based on the criteria are the two best things you can do in order to protect your record. So if there are like 3 criteria that you're looking at, and I remember when Wilda was on the Planning Commission, she would always bring the Planning Commission back to this and say, she'd say to Denny, okay, there's 3 things that we're looking at, right? And this is what they are. And he'd say yes. And the great thing about doing that is it brings it back to the record and to the criteria. So if someone then is saying, you didn't make your decision based on the criteria, you made it on this, being able to point to in the record where someone says, the 3 criteria that we're looking at are this, this, and this, and what I'm going to discuss are this, this, and this is why I'm making my decision, is so important. And lawyers that are representing the applicant can look at that and just know that their odds of success are going to be a lot less if there's a record like that that shows that that's the reason that that's the decision that is being made. Now, here is the one caveat to declaring ambiguous, which is the needed housing under ORS 197.307.4. We're in a housing emergency, and so we are going to, I think, be seeing a little bit more of this. What we're seeing as well is frustration from LUBA and LCDC both on housing supply and on cases where codes are interpreted to not allow housing or housing it, not allowing people to max out on their housing. And so there was some legislation last legislative session about that. It was actually in the context of affordable housing that could be built on church property, which was kind of interesting legislation because I'm not aware of any jurisdictions that have a quote-unquote church zone. Generally, churches are already in like a residential zone, an already zoned residential. They're a non-conforming or conforming use of that. So it's going to be interesting to see if the law is kind of shifting in that nature. What I would say is around housing affordability issues, particularly needed housing, you guys have to be really careful in how you're interpreting things. And
does that mean interpret it meaning that if you don't want affordable housing, that you can't block it from being there? Or do you mean it the other way around?
Well, one of the best ways to get blocked is if you say, I don't want this housing because it's affordable. And I remember years ago sitting in it, and it was one of your properties that kind of was going through a visioning process about, what can we do here? And the neighbors were saying things like, we have enough Section 8 housing in Milwaukee. And I was just thinking, like, that's not what we want in the record. But fortunately, the Planning Commission members were very clear that they weren't considering that testimony and that they were making their decisions based on the factors that staff had articulated. And so that is an instance. If a member of the Planning Commission had said, you're right, we have enough, and I don't want to do that, I mean, at that point, we take a timeout and we talk about whether that person should participate in it anymore. The The other thing that I'll say is there's never been an instance where I've heard a planning commission member or city councilor begin a sentence by saying, I probably shouldn't say this, but. And then at the end of that sentence where I was like, that was good, I'm glad they said it. I mean, it's been between like, it could have been worse to, I'm completely horrified they said it. So if your internal monologue is, I probably shouldn't say this, just don't. Don't say it.
Listen to
So this raises a question, for example, with the city goals and the housing needs analysis.
Yeah.
So if you determine that, I'm just going to throw out numbers, 80% needs to be residential, 10% needs to be workforce, 10% needs to be low income or whatever you want to call it, Section 8, whatever, 0 to 60% in the CET. If you meet that criteria, then can't that be a criteria saying, well, no, we don't need any more? You understand what I mean? Or we have way too much residential.
What I would say is if someone wants to build affordable housing in a zone that is zoned for that level of density, you would never want to say we have enough affordable housing in the city because you're just going to get a kickback. If there are criteria, if you feel strongly about a project, and let's say it's not because it's affordable housing, maybe it's just because the density level is too high for the place. Maybe there was a mapping error that happened at some point, or something was mapped at a higher density than the streets can accommodate. Whatever the factors are, you need to bring that decision back to those factors. So if the staff has identified criteria that someone needs to do to get a density bonus, then you need to decide the density bonus based on those criteria. You need to clearly articulate why you're rejecting or approving something based on the applicable criteria. And if you don't, if it's for other reasons, the risk of an appeal is much higher and the risk of losing an appeal is much higher. Interestingly, last legislative session, again, that the housing bill, there was a kind of a big housing bill that was just so interesting because it was like everything in the kitchen sink in it. And one of the things, there were a couple things it did. One is it allowed accessory dwelling units in R1 neighborhoods. And the second was it allowed people to go through expedited, for cities of a certain size, it allowed people to go through an expedited process as long as their density was at that level. It was as long as they weren't going for a density bonus. And it will be really interesting I'm not hearing that there's going to be any housing legislation during the short session, but it will be really interesting to see what happens in 2018, because there could be a lot of bills that could have a big impact on your
2019.
Yeah, 2019. In fact, Speaker Kotek has recently been saying that one of the barriers to housing affordability is city planning commissions and councils and local control, preventing it. And with the Speaker of the House is, beating that drum, that means legislation could come about. And there are all sorts, people are coming up with all sorts of ideas. Apparently in Massachusetts, there's a law that says, and actually Speaker Kotek's housing staffer, Taylor Smiley Wolf, is one that told me this, but if a city doesn't have a certain amount of available housing, then the local standards are no longer applicable, and it goes to a statewide entity that just kind of supersedes it, is how it sounded to me. I've not investigated that law, but I don't know whether that would be Metro or LCDC or who that would be, but those are the kind of ideas that people are saying to the Speaker's office. And so I might be back in 2 years, because we might have whole new rules around housing. So here's getting to another thing. So ex parte communication, it's just really important you guys get that into the record. And so you have the opportunity to announce it. You want to make sure that the other people on the council have the same opportunity as you. Obviously, this isn't something that's just generally, like if you saw something on Channel 8, about the project, then that's not ex parte contact. I mean, that's being published to the known universe. But if it is the applicant calling you on your phone and saying, hey, I really want this for my property, you need to get that into the record.
What if you see it on nextdoor.com?
Yeah, or Facebook.
That's what's the real.
I would always err on the side of disclosing, and then I would say why that did not cause you to prejudge it. And we've had instances in the past where people have gone to their neighborhood association meetings and a hot topic has come up, and the important thing that they've said is, I didn't participate in the conversation. I told them, I've heard Angel say this, I told them that this would be potentially be in front of me, and it didn't cause me to prejudge this. I'm viewing this with an open mind, and as long as you say that, you're going to be okay.
Just what are the time frames on that? So when there's rumor of a project long before there's an application or even
once the application hits, you need to be careful if it's speculative.
So once the application hits, any conversations after that are ex parte contact?
If you hear rumors around town of there being something that might happen, then that's one thing. If someone contacts you and says, I'm planning on putting in an application for this project, how do you feel about it? Even if they haven't put in that application, you need to, I would put that in.
Is it application or is it pre-application conference?
Yeah, that's an excellent point. I would say err on the side of pre-app.
Well, if that's the case, then somehow we all need to be notified about every single pre-app that comes across your door. Because each of us is in 100 conversations every week.
How do you draw the line between someone's idea or something they're kicking around versus
or just complaining about the number of houses that are being torn down? And
I mean, if you can't remember whether you had the conversation or not, it's really instances where someone calls you and says, I just bought Pietro's Pizza and I'm thinking of demoing it and building this whatever. What do you think? Was that something you would vote for? I mean, if you have that conversation, you probably need to put it in the record. If your neighbor's like, I'm getting sick and tired of people demoing houses and building larger ones, it's not a new project.
I was going to say, earlier this year, Denny gave us notice of one that was coming and said, and I asked the point then about, I'm seeing stuff about this on nextdoor.com, and his advice was, don't read it. And actually, at the time, I was like, well, that's stupid, but then that actually ended up being great advice. I was happy not to read it. I was happy to not read those interminable chains.
Well, and then that's another question, is Facebook and Nextdoor considered public record anyways?
No.
But if a news story on KGW is...
No,
does it come down to if it's available to the public, if I can go and search for it?
Yeah.
So public record for the purposes of the application is what's in front of you as a planning commissioner or city council member. So if someone sends you an email about the application asking you to do something or not, then you'd want to forward that to staff, because you want the other planning commission members or other city councilors to have the same access to that information as you, to the extent that you can. If it's on Facebook or Nextdoor, again, I would urge you just not to read it, and then to say, I'm aware that there was some chatter going on Facebook or Nextdoor, under the advice of our staff. I didn't read those, and I'm coming at this with a completely open mind. I'm not prejudging it.
what if it's, a dozen residents tweeting at Mayor Mark Gamba on Twitter? And unless he ignores all those, is that a form of direct communication?
If they're urging him to do something, I think then he would say, I got a number of tweets from people urging all sorts of different actions on this, but, I haven't decided what I'm going to do. I haven't made up my mind. I'm not prejudging, just,
And should he be putting those
Probably shouldn't
tweets in
answer
the
the
record?
tweets.
Like if Will says Simon says,
Well, right, if you don't answer, it doesn't mean that you've ignored them.
yeah. 'Cause
Well, but if you
it's-
read them, you can, it's not that you gave them a response, it's that you absorbed them.
Yeah,
That you took them in
that's the
as,
same as an email.
Right, but
Yeah,
the question is that technically, did you not read them if you did not respond?
How do you know someone read an email that they sent? Unless he responds.
I mean, it's kind of hard to say.
I mean, the key is to the extent that you can, and again, all these rules were made pre-social media. The key is getting it in the record so that they have an opportunity to respond. So let's say that you get 100 tweets and emails around cell phone towers, and people are like, cell phone towers cause cancer. Here are 5 articles that demonstrate cell phone towers cause cancer. And you read them and you're like, cell phone towers cause cancer, there's no way I'm going to vote for this. Or just like, wow, I'm very concerned. I didn't used to have a problem with cell phone towers, now I do. It's getting it into the record. I've gotten some emails on this. I forward them to staff. They're about whether there's a correlation between cell phone towers and cancer. And I am coming at this with an open mind. I have, that's not going to be a criteria anyway, but, if you said I'm not going to vote for a single cell phone tower because I've read these articles and they cause cancer, I would say you need to recuse yourself from this because that's getting awfully close to the bias of I was elected to cite this church. Yeah. So again, like the most important part of this is that to the extent that you can get it in, you get it in. And that they have an opportunity to rebut the substance of the communication. Because if you're relying upon it to make your decision, then they need to have the opportunity to say why they're wrong. That's why this rule exists. It's not because, someone stopped you in the store and said, you're doing a great job, but I hate that apartment complex project. Then you might say, people saw me in the store and talked to me about this apartment complex. I haven't made up my mind. I haven't prejudged the application. I'm going to base it off of the criteria. And just keep bringing it back to that. Those are the factors. Even if you're like Commissioner Huddle, it's like, we got a big win, but it's not over yet, And then 2 months later, it's about to be over because he's the deciding vote on the matter. Like the key to that is he was able to remediate himself through careful communication. He was able to establish to the courts, for the court, that he wasn't biased. And, that was some fairly extreme. He ran on a no LNG. That was his platform. So if he can remediate, you can remediate.
Somebody needs to send that paragraph to Warren. He's going to need it.
yeah.
I can't possibly comment on that. I have a deputy special prosecutor in Clark County because all of their lawyers were conflicted out. So I represented the auditor in the determination that Don Orange, in fact, said he lived where he lived. And I have no idea what's going to happen with that now. That was a lot of police in that room, though, for that hearing. This reminded me of Damascus. So, ex parte communication not disclosed. The party's right to rebut the substance of the communication may take the format of a mini hearing. And so this is if this is part of the bias one. So if someone hasn't disclosed ex parte communication, then someone has emails, or let's say like you replied back and you're like, you're right, this apartment's bad, and against it and you didn't disclose it, it's gonna, and they're like, this guy's, this can't participate in this decision, there's bias. That's the de novo review. And the higher local decision maker may cure a procedural error by providing an opportunity to review the evidence and provide a rebuttal opportunity. So if planning commission's made a mistake, or if even city council or a counselor has made a mistake, reopen the record, give them an opportunity to respond, and in that case, we might be able to cure it. Or we might need to go back down, and then it's just a determination that you and staff would make about what's the best course of action.
Now, I have a question about that. Let's say it's unanimous vote.
Yeah.
All five people are there.
Yeah.
And you have one that says, oh, this person was biased.
Mm-hmm.
Wouldn't you say, well, then the vote would be 4-0 if they would have kicked him out?
Well, their argument would be that your advocacy on the issue swayed the others, so that they would make the argument that one bad apple poisons a barrel, and that's why the duty is not just your own; it's to your fellow counselors, because what you don't want is this application to come back. I mean, there's some hard applications you have to deal with, but a lot of them aren't hard. They could be time-consuming, though, and they could have a lot of public testimony, err on the side of disclosing, explaining why you can or can't participate. If you truly made up your mind on the issue, don't participate, because your duties are to not be biased and to be able to fairly look at these things and not have prejudged them. And so if you've prejudged them to the point where they can't say anything that's going to change your mind, you're convinced you'll never allow a cell phone tower in the city of Milwaukee, and you'll vote against everyone, recuse yourself. Because, that's what our system requires.
So on that, I know this, I don't mean to just keep asking questions.
No, ask away.
When staff gives you an opinion in your packet, doesn't that create bias?
No, because how much weight you give to your staff's opinion is up to you. So you can give that a lot of weight, or you can give it very little. It's the same thing with expert testimony. You can have a very compelling expert, or you can have an expert, that's got a great resume that you just think this person has no idea what they're talking about, and I believe that Denny does, or that my staff member does, or the expert that we hired for our traffic study does. You determine how much weight something deserves to the extent that you've got dueling experts. You just need to explain why you've given the weight to one versus the other. And it can't be like, I always side with our staff. It should be, what I heard Denny say was this, and one of the last times I was out here, staff had looked at traffic studies, and they'd said, there's a book on traffic studies that's nationwide that people look at that has been recognized by courts as having accurate information, and this is what it said in this instance. And in that case, if the other side brought in an expert and said, no, this will generate half of those trip counts, or this will generate double, what you would want to say, if you really wanted to do a favor for your lawyer, is this is the one that this is the standard that I'm using, or the expert testimony that I'm relying upon. My understanding is that this was prepared by using these materials that have been previously approved by courts, or I gave more weight to this testimony. I found it compelling. I'm familiar with, our staff's familiar with, X, Y, or Z, or our staff said there wasn't a TriMet stop within a half mile, and so people are more likely to be using single occupancy vehicles, or whatever it is. You tie it back to why you're giving more weight to one than the other, and then in making your decision. So you make your decision based on the applicable criteria. If you do that versus something extraneous, you're in good shape. If you explain why one expert is more compelling than the other, and that's why you're making your decision, you're in good shape. if you never say, I probably shouldn't say this, but, good shape. So these are all things that you can do. So err on the side of a complete record, because that's the Fasano case, which is the one I mentioned previously. One of the ones I mentioned previously. In that case, they were citing a trailer park, 32-acre trailer park in Washington County were the facts, and there wasn't sufficient record for the reviewing courts to determine why they had made the decision they had made. The Washington County Commission said, yeah, this meets our criteria, and that was it. I mean, literally, it was like, yeah, this meets our criteria. Why does it meet the criteria? I mean, you don't have to go full William Faulkner and, have, paragraphs, but a simple explanation of, I find this does meet our criteria. I find this is compelling architecture, or whatever it is. That was the last time I was at the Planning Commission. I mean, that was a question I think was like exceptional. And this is why I think this is, fortunately I'm an architect, it was like, this is why I think it's exceptional, and these are the elements of this design that I really like. And other people said the same thing. And that provided the basis for that decision that allowed the bonus that the applicant was seeking. And that's a record that I really like having versus, yeah, this meets the criteria and we're gonna vote. It's saying what the criteria is. The criteria is exceptional architecture. Here are the elements. I can't remember if that was a criteria or not, but I'll say it was. Here are the elements of this that I think, creates visual whatever downtown in the downtown area. And I feel they meet this bonus because of that. That's what you want in the record. And then you're making your decision based on the criteria. And then we're pretty good because you guys are entitled to a whole lot of deference. So it becomes harder for the folks that are trying to attack it. So here's, again, weighing professional versus lay testimony. So the substantial evidence standard, whether the evidence in the record would permit a reasonable person to make the disputed findings. So that's a standard that's in a lot of land use matters, particularly like a UGB expansion. So if you guys are going for a UGB expansion and
You will never be.
Which never will happen.
Just so you know,
Terrible.
in case anybody here is curious.
If you were to cherry stem all the way out of this area.
To Damascus, yeah.
But so the substantial evidence standard is whether the evidence in the record would permit a reasonable person to make the disputed finding. So this is in a legislative matter. So like the urban and rural reserves, which have been going on since 2007, which some of you have been following probably, that is the standard that people that say that, so let's say something was designated a urban reserve or a rural reserve, certain findings needed to be made. So that in the Stafford Triangle, some of you might be aware that is, cities of Westland and Tualatin said that the traffic analysis that was necessary did not meet the substantial evidence standard because a reasonable person could not make the finding that could be served by the transportation given what was in the record. And what was in the record was a lot of this can't be served by this transportation and not a lot of this is how we can serve this population by that. And so they got it remanded. Jeff Condit got it remanded based on that argument. He said that there wasn't substantial evidence in the record. A reasonable person could not make the disputed finding. So the testimony must address whether the approval criterion is satisfied. Expert testimony may rely on opinions of expert in determining compliance with criteria. You are not required to accept an expert's opinion, even if it's uncontested, as long as the findings explain why the expert report is not viewed as credible or reliable. So, and if there's only one expert and no one's rebutting it and you don't think they're credible, you need to be really careful in explaining why it completely lacks credibility. What's more, you're going to see more often is conflicting traffic engineers maybe the resume of one expert, to the extent that you have it, doesn't establish credentials. Maybe they did a report the year earlier that said something else, and so you're going to use that to, impugn the next testimony, which is, 2 years ago you said this, or 6 months ago you said this in this jurisdiction, and now you're making the exact opposite argument in this jurisdiction. That's that's something that could come in and give it, maybe they did a housing needs analysis and maybe they did a second one and they say two different things, and then you might believe that because of that their testimony lacks credibility, and if you do, then that's what you get into the record.
So there's no problem with us doing our own research on experts that are testifying, as long as we put what we found.
If you're going to be an investigator, you need to put it in the record. But there are instances where you may see the experts time and time again, and they may say something for one applicant and they may say something very different for another. And I've seen instances where members of the city council or planning commission were like, wait a second, 3 months ago you said this, what's changed in 3 months? And that can get really uncomfortable for the expert, because if someone's like shaking report number 1 at them while reading report number 2, what are they going to say? And maybe it's that something dramatically changed in that period of time.
In that case, it's completely okay if they provide more evidence, like due to recent discovery.
Oh yeah, absolutely. And if they were to say, well, because the population projection that we were relying upon at this point is X. Metro just released a new urban growth report and it says Y, and this is why I'm making my decision, then that second determination could have complete credibility. So if they can explain it, they can explain it. Ultimately, it's up to you to decide whether their testimony is credible or not. So they could give a reason, and you could say, that doesn't ring true. What does ring true is what I relied upon 6 months ago when you said X. And Metro's urban growth report said Y, or whatever it is. It's just explaining it and putting it on the record to the extent that you believe in one expert or you don't, or why you give one expert more weight. Expert A is saying exactly the same thing that you said 6 months ago, and now you're saying something completely different. I believe your 6-month-old data in this expert because that expert's explained why the situation on the ground is unchanged. So it's that sort of thing. Again, it can be as simple as I put a lot of weight in this person's testimony because of X or Y. Just get it in there. If nothing else, say I'm giving more weight to this expert. Even if it's that really helps, because then we're saying, well, they gave more weight to that expert. It'd be nice if you said because of this, but just clearly articulating why you're giving one person more weight than the other, you're going to be entitled to a lot of deference in that. So that certainly helps out.
So that actually begs the question of, you might give one expert more deference because of something you already know about that issue or that something. Is that an allowable thing to say?
I mean, I think that what you could say in that instance is, all evidence that I've seen on this in this matter, really, the overwhelming amount of evidence points to what expert A is saying, and other people have placed, whether it's articles or whatever, into the record that is completely consistent with expert A's testimony. It's not consistent with expert B's testimony.
But that's if somebody else brought something into the record.
Or if
what I'm saying is that you didn't have that. You had two experts.
Well, when you're in the quasi-judicial, you're a judge, basically, and so it's the evidence in front of you.
So if they can't speak to that evidence, like I don't have any evidence to support why I think expert A is better than expert B, is that biased?
No, I mean, sometimes somebody seems like they know what they're talking about and someone else seems like they really don't.
I guess how do you quantify that? Because I see you.
You just say, I really didn't find the evidence of expert B as credible as expert A.
Persuasive.
I found expert A's testimony quite persuasive, and they have been doing this for 30 years. Expert B's testimony was far less persuasive.
Okay.
Just putting it like that.
So checking in with the group, it is 8 o'clock. You have, what, 8 or 10 more slides?
Let's check.
Ballpark.
Oh, a few more. We can roll through them very quickly.
Okay.
Also, ask a question.
Everybody okay?
So expert testimony is not necessarily presumed to be persuasive, but the decision maker should clearly explain. We've already said that. Goalpost rules. So it's the standards and criteria existing on the date of the application that was submitted and governed. This is something that oftentimes city councilors or planning commissions don't think is fair, but that's the rule. So it's when they get it in that matters, not if the rules change during the course of it. Disruptive behavior, I think this is the last slide. Disruptive behavior, what can be limited? So this can get pretty tricky. Signs are allowed as long as they're not blocking the view of others. So if someone has a sign like this that says, say no to density or whatever it says, and they're holding it on their chest like that, they're not disrupting. If they're blocking the view of other people, they're disrupting. If someone's testifying and someone else is yelling at them, they're disrupting it. If they're wearing a t-shirt that says whatever their t-shirt says, they're not. So it's about what is their impact on other people in the room. And so Clackamas County tried to ban signs, if you recall, a number of years ago.
It was a disaster. Circus. Hey, in our case, since we don't have a police officer, well, I guess you guys have a police officer, but if the planning commission doesn't have a police officer, who supports them?
Usually if you ask them to behave, they will.
If not, then it's the city attorney's job?
I remember one instance where I told a group of people that they were over the maximum number of people in the room and they needed to, where they were all standing behind the city council, and we got down to like 54, and so that was the job of the city attorney in that instance, and I told them to count it off, and they did. And we had however many in the room, so we didn't have to call the fire marshal. So this is after you close the record. Sometimes questions will come up, and so the question is whether they're factual or substantive. And so if it's like, don't we have a code section that deals with this? Then you can absolutely say, yeah, here's a code section. If it's, what's the standard? What does the case law say about this? Or what do you think about that? Or anything like that, you need to reopen the record. So if it's something substantive versus factual, or whether someone's needs to offer an opinion versus it's this section of the code, will determine whether you have to reopen the record or not. Ex parte communication is discovered after the fact. Again, like the most important thing is to have a right to rebut, and then the de novo review may cure. Hopefully we won't get to that because hopefully we'll get it in early. And then the last are around exactions. So this is the latest case, Coons, which says that monetary exactions are exactions, and it goes back to the Nolan and Dolan test. Nolan is nexus, so it has to be closely related impact. So if someone's building, a lot of apartments and there needs to be a traffic signal, that's nexus because those apartments are going to generate a lot more traffic. That's what it looks like in nexus. If if someone's looking to like add 500 square feet to their building and you want to do make them do something like on a neighboring property or like donate park or something like that, that might not be a nexus. Then the Dolan test is the nature and extent of the condition must be roughly proportionate to the proposed development's expected impact on the state interest. So if you have like a 3-house subdivision and you say, we want you to build like 1,000 feet of bike path or something like that, that might fail the Dolan test. If it's, oftentimes it's something that's just incredibly expensive to construct and the benefit's pretty small. So if someone's looking to the Dolan where the city of Tigard didn't meet the test, they wanted to expand their parking lot and Tigard said, you'll give us a bike path. And the United States Supreme Court was like, no. So anyway, that was before my time.
You learn about it in school.
So monetary versus non-monetary, this is again Kuntz. Before Kuntz, there was some question about whether a monetary exaction was the same as making you build something. What Kuntz demonstrated is it is. Finally, testimony by a planning commissioner at council. I always say this is not a good idea, but people have free speech rights, particularly if your testimony is like, this is why we decided it, and it's not the conditions that you so carefully made your decision based on. That's really the greatest risk with that, is just that you can undo a lot of good work through your public testimony in front of the city council.
On that point, this is going to be a question. It would be very interesting for council in some cases to know if it was a split decision, what the minority concept was for what they thought. Is that something that can forward in the record or that a commissioner could come testify as to?
I mean, I assume that's going to be in the record and you can watch the hearing.
Yes, you can watch, obviously, you can sit through 6 hours of hearing on.
Well, but to know that this, at the voting point and the dissenting, that's all
I mean, your
fairly
staff
concise.
can probably tell you where it is in the tape.
Oh, yeah.
So I would just ask Denny and be like, hey, so this looks like it was a 3-2 vote. And he'll be like, yeah, after 3.5 hours, they kind of got to it. And then you can watch the 5 minutes where they got to it.
Yeah.
Having them come in, reiterate their testimony, I mean, my concern would be if it's one side and not the other, is that it's demonstrating that you're off, out of the blocks, giving more weight to one side than the other. And, I would just be concerned that if you, let's say they approve something, it was 3-2 vote or whatever it was, people thought you might not like it, you bring in the people that voted no, they testify why they thought the planning commission was wrong, and then, you guys reject it, that would cause me concern if I'm defending that record, because, I would be arguing, of course, that no, it's, minority reports are regular business and, whatever. But it's there in the record for you to see if you want to see it. It's there in the record for the general public to see if they want to see it. And if you found that someone made a really compelling point, like that's in the record. And, I've heard people say, I watched the prior videos, I've reviewed the record as a whole, which is a really good thing for people to say, because it demonstrates that they're, reviewing all the materials and making a reasoned decision. And you could say, so-and-so made a really strong argument, and, this is what it was. You have to balance that with the fact that you haven't made up your mind in advance. But, if someone puts something into the record, you can certainly point to it and say, here it is, I found this persuasive.
And we had a situation, one of the applications, recent applications, where one of the planning commissioners wasn't at the meeting, but had put in some thoughts and questions and comments in writing. And I found those very helpful, even though they weren't able to be part of the discussion. They still, I thought, there were things that gave me things to think about when I was looking at
But it was part of the record, so
It
we
was
all
part of
read
it,
it. And
yeah.
that's the point, that we all
Well,
are
and
watching the
that's-
same video and reading the same testimony.
Yeah.
So when we get a packet that's like that, and it coincides with 9 hours of video from the planning commission,
Which we all watched.
it seems a little
Guess how you
unreasonable
spend
not to
your
be able to
Sunday.
just ask for a minority report to condense the 9 hours.
What I would say
It
is,
doesn't come in the,
right, what I would say is, if you're going to do that, you should do it for all applications. And so you should say, we always look to see what the planning commission vote was. To the extent that it was a split vote, we asked the minority to prepare a minority report. This is what they said. It's a max of 2 pages, and we do this for all applications. Because what you don't want is someone to claim that you've prejudged it, and that's why you asked for a minority report in this one instance, but have never done that previously.
Yeah.
So is the challenge just there's so much information that has to be consumed by the public that that's not happening, or you keep mentioning
By
6 hours
by
of video.
us, yeah.
well, by us.
Yeah.
We're supposed to, when, it comes to us,
Yeah.
either because it was always going to, in the case of, actually it's still open hearing, or it's been appealed, then we have to not only read our packet, we have to read the planning commission's packet. And if we want to be privy to what the conversations were, what the thought processes were from the minority report, because we'll get the answer, the decision that comes out of the planning commission, that will be in our packet. But we won't necessarily get what the dissenting concepts were in our packet. So we would have to then, on top of reading all that stuff, go back through and watch however many hours of video.
How much are you actually trying to watch? Is it the whole 6 hours, or like
It depends
here and there?
when the conversation, how do you know when that conversation took place? The irrelevant piece that,
Well, the beauty of YouTube now is that it does, tab it.
Helps you
So you
aware.
go public testimony part, you go back to the staff, you go to the applicant, you go to the deliberation. So you can pick and listen to some and decide if you need to go listen.
And
to
staff
more
can tell
or
you.
not.
Denny and Brad are going to know when the meat of the discussion happened, to guide you.
The
Again,
other thing is you don't really have to watch. You have to listen, right? You can be reading your packet.
you can read and listen to somebody talk.
Kind of like saying I'm on text and drive, Lisa.
I could be cleaning house.
You could be doing your dishes. You could be cooking your dinner.
No different than audio books.
I occasionally stream meetings while driving.
Yeah.
I'll listen to. I'm not watching it. I'm listening to it on my Bluetooth device, hands-free. So if you're going to do that, a minority report, just do it totally consistently so some applicant can say, you were always against this, and you asked for a minority report, and you've never asked for a minority report before. Because that's really the concern, that that's what they'd be able to claim. And then, you're on the defensive of, no, I'm somewhere to the right side of the huddle up,
Yeah. So I had a couple other questions. I know we're trying to get out of here. The issue about extending a meeting because there's been additional evidence. There's been new evidence, or new. I'm not talking about the appeal, new evidence thing. I'm talking about at a planning commission hearing, there's been something new, and so the applicant can ask for an extension to be able to respond, or can anybody ask for an extension to be able, including a planning commission?
So someone could ask for an extension, and where this comes up, where I've seen this come up most, is there are some planning commissions that may disagree with their staff on criteria and will then say at the planning commission meeting, I believe there are additional criteria that apply, and I believe these are the criteria that apply. And so the last time that happened, it was not in Milwaukee, it was in another jurisdiction. You know, the applicant obviously had no idea. And so I said, do you believe the application has met that criteria? And that commissioner went through all the criteria and believed that they had. And so I said, well, whether or not the criteria are applicable, you believe they've been met. So if you believe that the criteria that your staff has created, and no members of the audience wanted to rebut, the applicant certainly didn't, and there actually were no opponents on it. As long as everyone believed that all criteria had been met, which they had, then we didn't do that. In an instance where they did not believe they believed additional criteria were met, and they didn't, or they believed there were additional criteria, and they didn't believe they were met, then we would want to give the applicant an opportunity to respond to those, probably a later in time meeting, and we want to give staff an opportunity to respond to those. Staff might be willing to respond at that meeting. They might want some more time to consider it, but that's the instance where I've seen it come up the most often. If there's really late in time evidence that's from a member of the deciding body, that's another instance where, I would say to the applicant, do you have time to rebut this? And sometimes in those, it's going to be a multi-week process anyway, and so they're going to have time. But if it looks like it's going to be quick and it's all going to be in one night, and whether it's criteria or new evidence that literally came out like 5 minutes before the hearing or whatever.
Well, yeah, say somebody brings they bring a new traffic study, or they bring or the people opposed to it bring some kind of, just have tons of testimony or whatever.
So if they bring testimony, then the applicant could ask, and someone might bring a new traffic study, but you guys might not feel it's credible, or your staff might not feel it's credible, and they can explain why. If they think they need more time, they can ask. If the applicant thinks they need more time, then they can ask. What we don't want is like a gotcha type of situation. So as long as, that's why you ask the question, like, do you need time to respond to this to the applicant or your staff? Because what you want is accurate information. So if there's an explanation of why it's wrong, or if staff decides, wow, this is right, they saw something that we missed, and that might be the end result. They might need 24 hours to figure that out. And then, if we want to get the best evidence and the right result, then, it's a good idea to do that.
My other question is about, I think we all know the process for appealing from Planning Commission to City Council and then to LUBA, but that's for quasi-judicial. For legislative, if somebody doesn't like what we do legislatively,
it's appealed to LCDC.
It's appealed to LCDC.
Right.
It's not it can be referred to the ballot.
So it goes to DLCD sometimes, and then it's the staff, it's the director determination that's made. Then that could be remanded down, or the director could do it. They do a director's report to the board, and then the opponents get to do what are called exceptions of why it doesn't comply with land use goals.
If it was a post-acknowledgement plan, for like amendment to the plan, if somebody wanted, it would be, a post-acknowledgement plan amendment.
Wouldn't it be appealed to LUBA? Even a text amendment or a...
Yeah, in that instance, it would likely.
I mean, the only time you get to LCDC is when you're in periodic review, I believe.
Or, yeah, I mean, anything, well, you guys don't have to worry about UGB, and you guys don't have to worry about the, like Metro's urban growth report, like if they were to make a determination that you needed more, that would go to DLCD. If they were to make a determination that they didn't need to add any more, that would go to LUBA, interestingly enough, or that's what they claim.
So like our moving forward Milwaukee downtown code or our Tacoma Station area plan, if people wanted to appeal those in some way.
I think those they would appeal to LUBA.
Okay.
I really think that's the way that would happen. It wouldn't be, somebody could, DLCD reviews that material, and if they find an issue, they're going to file that with us. They're going to object.
That's during the comment.
But I don't know how something like that gets to DLCD. It gets to DLCD. I don't know how it gets to LCDC though.
So sometimes the director refers it to LCDC with the director recommendation, at which point the opponents or the parties get to file a letter of exceptions, and then the city would get to respond.
I also would just ask that you let us know what all the acronyms are, just to make sure that everybody gets that.
The DLCD is the Department of Land Conservation, or anyway,
LUBA's Land Use Board of Appeals.
LUBA's Land Use Board of Appeals,
LCDC's Land Conservation and Development
Commission.
So DLCD is the staff to the commission. And we could probably continue on with a zillion other.
Yeah, and so like a DLCD director determination would then be appealed to the LCDC board, which then goes to the Court of Appeals. So you can see this is why like you don't want a goal one problem, because the last thing you'd want is to go all the way up and then have a goal one or goal two problem and have to start over. Because using the urban and rural reserves as an example, that's been going on since 2007. So that's something that went up to the Court of Appeals and has come back and is now at LCDC. And it could continue. So these things don't get resolved overnight, which is why we want the cleanest possible record. Because it really, if you have a very clean record, that in and of itself will make people not appeal. Because people, unless it's someone that, I mean, there are instances where people appeal because they don't want a project to happen. But if there's an applicant that gets rejected and the record's really clean, that applicant might not appeal because the record's really clean. They might instead work with your staff in order to come up with a project that meets your vision and values, because they know that the time and money associated with the appeal is not likely to be successful based on the record. Whereas if you don't have that kind of record, or you haven't made the decisions based on the findings, they might be able to win at that level. And then a lot of times the jurisdictions like LUBA remanded it back to us. To a lot of people, that means, you did something wrong. And so, it just creates a different dynamic. And it's no fun to see things a second time. All right.
Thank you.
Thanks.
Thank you all very much for coming, for taking to absorb.